let me know if it is visible.
Yes, it is visible.
Thanks, Ravi. Okay, so hello everyone. I am Shreya. I was from 2011 batch, I mean the second batch of life sciences. So currently I'm working with Inventia Limited. It's a European based company. It's a consultancy company. And there I'm working as a manager IP, which is intellectual property rights. And I have also cleared the Indian patent agent examination. So in India, I have the authority to file Indian patent. So this is what I'm known as registered Indian patent agent. So now today we'll be discussing on how life sciences, which is our domain here, is connected with IPR. So the agenda of today's our get together is what is IPR, types of IP protection, patents, which is more relevant to us. Rest of the IP protection is not relevant to our field. Now, careers in IP. So what is IPR? IPR is intellectual property rights. If I'll tell you in a layman's term, property, if we say property, we know land, houses, cars. So that is the property which we own. But intellectual property, which comes from our mind, it's not touched. I mean, we cannot touch that. That is an intangible property. But we can have our rights on that. Our idea. Remember, we cannot have the patent on idea once that is an innovation. One, we can form the idea into a document or into a equipment something, then we can patent that. So that is an intangible property, intellectual property rights. Now, if we'll go for the definition, so intellectual property rights refers to the legal rights given to the inventor or a creator. So the word itself, you know, who are the inventors? We science people. We are the inventors or the creators. I mean, the one doing the science, I mean, no one from the BCom or BBA people will be able to get this right. So this is related to science. So given to the inventor or creator to protect his invention or creation for a certain period of time. We get patent for a certain period of time because after that it'll be in the public for their public use in the public domain. Now these legal rights are an exclusive right. We have the exclusive monopoly right over it. I mean, if for example I discover this pen, I mean this is already in the market, but I discovered something, a torch in the pen. Let's just suppose it's a hypothetically, it's something new, it is not present in the market, so I can patent this. Whereas I'll also let the examiner know that this pen is not something new. It is already present in the market, but the torch attached to the pen is new. So I want the right on the torch attached to the pen. So if I file the patent, no other person can get this idea, can copy it, because then you'll have the right to sue them. So, and now I'll let you know how this will help us in the company process. Sorry. Yeah. Now, what I was telling about is patents, which is relevant to our field of work. But rest are copyrights. Copyright, as you know, the songs, literary works, novels, anything which is written, that is automatically copyrighted. I mean, you don't have to file any document to get the copyright. If you have written something, if it is the web or it is with the literary format with you, it has copyright and it has got years of around 60 years from the death of the person who wrote or who created that. So that is a long time, I mean 60 years. Now the next is industrial property, in which these are the classifications. Trademarks. Trademarks, if you'll know, it's a brand name IP protection. For example, if I'm opening a company and I've named it as Shreya Enterprises, so I've trademarked that company and I've registered it. No one else can copy the trade name of Shreya Enterprises because it belongs to me. And the benefit of the trademark is, if for suppose Shreya Enterprises deals in selling shoes, for example, and it is famous, for suppose hypothetically it is famous that whenever Shreya Enterprises name comes, it is connected with the shoes. So if any other person try to copy that, so obviously if if you say another company opened it with Shreya Enterprises, the layman people, the consumer, will they know that, okay, that is also Shreya Enterprises, so their shoes also must be of good quality. Why? Because my shoes has the goodwill. So the trademark is very important because if I have the trademark, I can sue that person. So trademark is not automatically granted. Only copyright is automatically granted. Trademark you will have to file in the Indian Patent Office. That you have the once is the trademark, and once it is under the registration, you can use it anywhere you want. But this is also applicable in jurisdiction. All these IP rights are applicable only in India. Why? Because I'm filing it in India. If any third person is copying in USA, you cannot sue that person because these intellectual property rights are based in a jurisdiction. US has its own laws, Europe has its own laws. So those laws is not Indian laws are not applicable in US and neither in Europe. Now the thing which is our concern is patent. As I've already told, that patent is an exclusive monopoly right given to the inventor or the creator. The next is the industrial designs. Industrial designs, for example, design of a car. I mean, how the each car has its own design. I mean, Lamborghini or Jaguar, it has its own design. So obviously they have uh, I'll not say patented. Patented is not the word. They have got the IP protection. That is the industrial design property. I mean, no one can copy the design of the look of the layout of the Lamborghini car. No one. So that is the industrial design. A simple example is Coke bottle. Coke bottle has also got a typical shape. I mean, Pepsi bottle is not same as Coke bottle. So that is an industrial design. So that is has also got IP protection. It is also very important because why? We as a human being, we have got a tendency to connect one thing to another. If for a suppose the wrapper is removed from Coke and Pepsi bottle and both the designs are same, we'll think, okay, both are the Coke bottle, and since Coke is so renowned for its taste and everything, so we'll automatically say, okay, this also must be nice, tasty, because this bottle size and the shape is same as of the Coke bottle. But that is not the case because we have already removed the wrapper, and the another one is the Pepsi bottle. So filing the industrial design will help prevent these chaos. Next is the trade secret. Again, the Coke example. If you know that Coke, taste of Coca-Cola and taste of Pepsi, they are not same, but somewhat color and everything is same. You know why? Because there's a theory that, I don't know how many years before, when Coca-Cola recipe was created, it has already been passed down to 3 to 4 people, not the whole company. No one knows the recipe of the how Coca-Cola is made. So that is the trade secret. And since this is known as trade secret, you cannot disclose the trade secret to Indian Patent Office as well. You are just filing it. That okay, Coca-Cola, I'll not disclose the recipe to the Indian Patent Office as well because no one should know about the recipe. But we'll just file a document that this is a trade secret of Coca-Cola so that no one can copy it. I mean, Pepsi did try to copy it by reverse engineering the whole recipe, but obviously we know the taste is not the same of Pepsi and Coca-Cola both. And the last one is geographical indications. Example will be Darjeeling tea. I mean, we know Darjeeling tea has a specific taste. Kangra tea has a specific taste. So, as the name suggests, geographical indications, the things which are related to the geography of it. I mean, for Bihar, we have Madhubani paintings. I mean, recently we had one dispute between Orissa and Bengal of the Rasgulla, whose domain this Rasgulla will belong. So that is the geographical indications. Now, coming back to patents, which is our major domain. So as I said, after filing patent, we'll get an exclusive and monopoly right of making the things which, for whatever you have invented, using it and offering for sale, or maybe licensing it to a big company. For suppose you came up with a drug, I mean something new drug, you can license it to any big company. I mean, Cipla, Novartis, anyone, and you will get that benefit, the royalty of it, whatever income, whatever business they'll be getting based on that drug, you will be getting the sole amount of it. So that is what the beneficiary of filing a patent is. And the amount of time with patent will be granted is 20 years. But to be honest, in India, it takes around 5 years to get you the patent. So the date of filing is considered as the first day of the patent. So for suppose I file a patent tomorrow, that is on 9th July 2023. So from tomorrow onwards till 20 years, I have the use of patent. But during these 4 or 5 years of getting the patent, there are a lot of stages in filing a patent. I mean, first, the most important thing is examiner will see that your patent is novel or not. The subject matter on which you're filing the patent, it's novel or not. I mean, if it is not obvious, for suppose I gave you the example of a pen with a torch. So the pen is not novel. It is already in the market. I mean, everyone is using it. Everyone knows about it. But the torch attached with the pen is new. Maybe there this concept is also present in the market, but the ingredients which you used in the torch, I mean, I'm just using hypothetically, so bear with me. The ingredient or whatever the composition, whatever is used in the torch is new. Then you can file a patent using the process of the torch, how the torch is made. Since the torch is also already in the market, so you cannot file for a product patent. But how you have formed a torch, that is a different thing. That is not known to the world. I mean, not in India, sorry. That is not known in India. Then you can file a process patent. So in India, we have two patents, product patent and the process patent. And unfortunately, in India, we do not get patents for software or genetically modified organisms or plants. I mean, there's no permission in India for filing patents of these, but in US, yeah, in US you can get patents in all of these criteria. The next criteria is non-obviousness. As I said, it should not be obvious. I mean, the torch is obvious, but the process of making the torch is not obvious. So I may get that patent. And the rest is utility. I mean, you cannot just frivolously file a patent which has no use to the market, which has no use to the society which we are living in. I mean, for suppose you just developed an invention which is only solely used for your own sake and it is not useful for me or any other third person, so you'll not get the patent. Patent is something which is used and granted when it is sufficiently used in a market and it can be developed in a factory. I mean, an idea obviously cannot be developed in a factory. You have to convert it into a equipment or an innovation something, and that too it should be useful to the market. So that is the utility. So these three are the main: novelty, non-obviousness, and utility. If you are matching all these three criteria, then you are eligible for getting a patent. So this is what a patent is and what filing a patent and afterward entails about. Innovation, I've already developed a pen with a torch, and so I'm ready to file the process of how the torch is developed. Now protection, I filed for a patent for the protection. Enforcement is, for suppose I get during the 3 to 4 years, I'll get the patent. So I'll enforce it so that I'll let the publicly know that this belongs to me. This idea is mine. This pen with the torch belongs to me. And commercialization, maybe I can sell this license of manufacturing these kinds of pen and bringing it in the market to a company. So obviously, whatever the profits or the royalty which that company gets from it, so I'll be solely entitled to it. No third person will be entitled to the royalty. And if any other third person without your knowledge, without the license, is trying to copy it, then you can file the lawsuit against that person and obviously you will win. But if you're not filing the patent, you're just, this is your idea and you're selling it to someone else, just, for suppose, because it happens in India, I've heard 1 or 2 cases that, we students, when we work, we come up with something, you think that this is very small, we don't know what the use of it, and any company, if approach you, okay, this is something new, give it to me and I'll pay you this amount, and obviously we being naive, we go ahead with it, but you are not, but we should never do that. However minor or the small invention it is, you should file a patent. If you don't know about it, there are multiple free sources available on the net. I mean, we have a crunch of time here, or else I would have shown you how you can check that the subject matter is patentable or not. I mean, we have free sites. Maybe I can share the link later on, in which you can see that the subject matter which you are coming up with, is it already in the market or not. Now, see, this is the main thing. I mean, just 5 days before the patent agent examination result came for this year. See, this is very important if you want to pursue your career in IPR. Patent agent examination will give you the authority to file a patent in India. I mean, you can file a patent. I mean, being an applicant, you can file a patent, but you cannot go ahead with the prosecution. Filing a patent entails a lot of job. You have to file a patent along with a lot of forms. I mean, several declarations, several power of attorneys, and then once it is filed, there's a rejection and lot of correspondence between the examiner who is reviewing your patent and between the applicant. So you are not authorized to exactly go and sit in front of examiner and tell your clarifications. You need someone authorized to do it, either an attorney, I mean law, any law person, or being a science student. I mean, obviously we are doing BSc MSc, so we'll not move ahead and do law. So the patent agent examination is an alternative for us. If we clear patent agent examination, then we have the authority to go and fight our patent in front of the examiner and explain them that yeah, this is something new and it is not available in the market. So clearing the patent agent is important. And this year also, I guess more than 700 people cleared this examination, and it is not at all tough. I mean, for us being a science student, it is not at all tough. I mean, I just studied for 1 or 1.5 months and I cleared the examination in one go. So I am sure any one of you, if you want to do it, you can do it by yourself. And so this is the website. I'll share this PPT later on. So this is the website of Indian Patent Office, in which all the details are mentioned, all types of IP protection, whatever the notices are coming, everything is mentioned there. Now, how you can build your career in IPR. I mean, see, I have these 4 boxes. These are depending on the level of education you are in right now. For suppose, I have done masters, I didn't pursue for PhD. So I started my career from docketing. Docketing is something, the niche level of working in IPR. Docketing is something, if an attorney is filing a patent and he is corresponding with the client. So that in IPR field, that correspondence is also very important, because it entails all the deadlines, all the important features of the patent, which is confidential. So that a docketer will what do? They will record those correspondences between the attorney and the client. So it has got several softwares on it for the docketing. So docketing is the first stage, and this can be done by any person. I mean, the science background is not required for docketing. Here I've mentioned it also. Freshers can apply easily for this post. If you are pursuing your MSc and for suppose you don't want to go for the PhD, you can easily go for this job, and it is good pay also. And there are a lot of companies. I mean, in Delhi NCR, I can just say 15 to 20 companies working on this docketing project. The second is the paralegal. Paralegal also does not require the science background. Paralegal is something preparing the forms and packages. Docketing is recording the correspondences, and paralegal is what other than the patent. There are several forms and uh, requirements which need to be filed in patent along with the for the patent filing along with the patent. A paralegal is responsible for doing that. uh, Recently, you must be aware of the sequences. Obviously, we know what sequences are. In patents, we have to, if we are working around something sequences and our invention entails something or the other thing about the sequences, then it is our duty to disclose the same to the Indian Patent Agent Office as well, or any other office. It is our duty. We cannot hide anything. The filing a patent is something trade secret we have to hide, but for patent we should not hide anything. Why? Because patent is a document, and if anyone tries to infringe it, and if you have not mentioned each and everything, you will not have the proof to tell them, no, this is my patent and this was my idea. So everything should be included. In fact, more or less everything. For suppose we are using 2 grams of salt in our invention, so you cannot mention 2 grams of salt, because third person will use, okay, my invention is 3 grams of salt. So you cannot fight on it, because you have just specifically mentioned that I have used 2 grams of salt, and another person is mentioning 3 grams of salt. So you should what somewhat mention in the range. I have used 1 gram to 5 grams of salt. Obviously, I mean a reasonable amount. amount of range should be mentioned so that third person cannot copy it at all. So that is what patent drafting is. Hence, the science people are required. I mean, no other person can draft a patent. If I have to file a patent for a pharmaceutical company, then obviously life sciences people will be included in it. I mean, chemistry related patents, there are several patents including life sciences and chemistry, and I've drafted them myself. So this is something which science people can do. And there are several drafting domains. Mechanical has its own drafting domain, electrical has its own drafting domain. Obviously I cannot draft a mechanical patent, but I can draft a life science patent. Similarly, mechanical people cannot draft a life science patent. So this is what the life science can be linked to drafting. And for drafting, patent agent examination is not required, but it is a feather on the cap. If you have a patent agent examination, then your CV and everything will be considered priorly than the any other candidates. So appearing for the Indian patent examination will be a feasible option for any one of you who would like to pursue their career in IPR. And the next one is consultancy. I mean, this is something which I'm new in because this is the thing which I'm doing right now. I've just joined this new company 2.5 months before, and it's a Europe company which is providing the consultancy to the client. I mean, it is something new in domain. It entails searching. I've mentioned here searching, which I was telling you about. If you have an idea, you have to search if it is available in the market or not. If this is something new, should I spend the money? Because filing patent is an expensive project. I mean, you need money to file a patent. So I cannot just go and frivolously file a patent and it's of no use and my money is wasted. So searching is very important. So currently, I'll just share my experience that currently what I'm doing is I got to know from this job profile as well. Before I was a drafter, so I had no experience what this consultancy entailed. But consultancy will include that a client comes to me and he has this idea. So I'll take time. I'll do the searching. Even I do the market review as well. Okay, these kind of projects are available, but what you're trying to do here is something new we can pursue. And I can also, being a science person, and that is my domain, I can also tweak a bit and I can tell it, okay, you can do, instead of doing this way, you can present it this way, so that will be more feasible. So this is what consultancy company include. And these are the things being building a career in IPR include, I told you, registering Indian patent agent, IP attorney. That is, once you have cleared the Indian patent agent examination, you will be known as IP attorney. Drafting, drafter is something, I mean, who does not have a Indian patent agent examination as well, they can draft. I mean, drafting does not require you this certification. Searching, consulting services, and the starting IPR jobs. If, for suppose, if some of you are passing this year, and the examination of Indian patent agent examination will occur next year in May. I mean, this year it occurred in May, so I'm not sure next year when it will come. So if you want to pursue, then you can start with docketing and paralegal. Why? Because it'll give you an idea. Because any company you'll go, they'll provide you 2 to 3 months of training of what IPR is, what patent is, what trademark is, everything. So at least you'll get an idea what IPR is all about. And meanwhile, you can prepare for the Indian patent agent examination. And once you clear it, you can switch your domain. And yeah, this is the perk of IPR. You'll get a lot of freelancing jobs, lot of, because there are several students, there are several people who wants to file their innovation or invention, and so you'll get a lot of freelancing jobs. Now, where you can work as an IPR professional in any pharmaceutical companies, I mean, this is the best job. I mean, in-house. I've been aiming for this kind of a job, this in-house job, because you'll be only working for your company, no other client, so no pressure, nothing. So working in any of the pharmaceutical company, IP service provider companies, for example, Clarivate Analytics, if you've heard of that company, that is my previous company. It is a huge IP company and it hires around 400 people every year. So IP service provider company, consulting companies. My current company is a consultancy company, and even the big four companies, I mean, Deloitte, PwC, KPMG, EY, each has the IP domain. They have IP analysts, but yeah, they do require the expertise, because they generally hire people from IIT Kharagpur, because they have a specialized IPR course in IIT Kharagpur. So, I mean, I've already seen their CVs, so I know they generally hire from big four companies. Until unless you are, I mean, I'm aiming for it. After my consultancy company, if I'll get the proper expertise, I can even go in one of these companies. And law firms. Law firms, anyone can join. Any fresher can join. They'll give you a proper guidance and everything. There are several law firms throughout India. You can join anywhere. So the keynote of this is that IPR knowledge can be used worldwide. I mean, if you're once familiar with the varied jurisdiction laws, you can work anywhere. If, for suppose, you are doing PhD, you want to go ahead with the postdoc, and later on, if you don't want to pursue with teaching jobs or something, and you wanted it in a career in a corporate job, you can work in US as well if you know a bit about jurisdictions of that US law, and it is very easy. You can work on. I mean, I have several friends who went for postdoc and they are shifted there and they are working in this IPR domain. So this is IPR is something not restricted to India. You can go anywhere in IPR. In fact, India is the company which is filing less patents, and US is the company which is US and China. Obviously, they are filing many patents every year. So this is what the IPR is all about. And anyone has any questions, let me know.
Yeah. So anyone wants to ask any question? Go ahead and ask. Very nice presentation, Shreya.
Thank you, sir. I mean, if you do not want to ask right now, if something comes up in your mind, do ping me. I mean, my number is there in the WhatsApp group. Do ping me and I'll let you know. I even have the material. If an MSc candidate would likes to pursue in IPR, if you want to pursue, then do reach out to me. I'll give you the material as well to study. And if you're appearing for the Indian Patent Agent examination, I have the book and everything. I can help you if you want to.
Yeah, Shreya, I think I have contacted you 1 year before or
Yes, sir.
1.5 years before. Eh?
Yes, sir.
We
Yes, sir.
published a paper in Life Science. One journal is there, Life Science. So we
Okay,
published
sir.
one, and I got a mail from Australian patent.
Wow.
Yeah, they told like if you want to patent, you have published it's okay, but you have to come up quickly and within a month you have to file it.
Yeah. Hmm.
So why the restriction is like for a month?
So actually, it is not a month. I mean, they were just trying to have, I mean, hurry you maybe, but it's a
Okay.
year. Grace period is year because you've already published your subject matter. And the
Mhm.
one thing which is important in filing a patent is it should not be in the public domain. You already
Okay.
filed it, but 1 year grace period is generally given that you were not aware or something. You can file a petition and you can file a patent, but within a year. 1 month is in no country, 1 month is the law. 1 year is given to everyone.
Mm-hmm. Then I have contacted you that time. I think you are
Yeah. So I
your
was getting
marriage was
married.
going
Yes,
on
I was
that
getting
time.
married at that time.
Yeah.
Yeah.
So I could not file that, and I have inquired, and
Yeah.
I found somewhere the cells you are using, you need to procure those cells.
Hmm.
You cannot use a cell from anyone's other people's
No.
lab,
Yes.
and you
Yes.
cannot file
No. No.
the
No. Yes,
patent.
because you will even have to disclose what kind of cell and from where you have procured it. As I
Yeah,
said in patent, you have to mention each and everything.
yeah. That's because I we got those cells from Institute of Life Science, Bhubaneswar.
Yes.
So it is they who bought that from ATCC, American Cell Type Collection.
Yeah.
So I thought, okay, so many things are there actually. I left with that.
So, but then also, if that is the case, and if you have something, we can
Mm.
always file a provisional application. Provisional application is something the rough. You
Okay.
cannot change the subject matter. I mean, you have an idea what you want to file a patent about. In just a 1 or a 2 page, we can file a provisional application, and we'll get a grace period of 1 more year. And in that period of time, you can come up with a more clarity that how you want to pursue with your application, and then we can file a non-provisional application. That will be the final application, because provisional application will give you the claim and the priority, and no one can copy you post that. You will have that claim with you. I already filed a provisional application. So that filing claiming priority is very important in patents.
Okay. So in future also, if some like
Yeah.
chance come, I will contact
Yes,
him.
sir. Sure, sir.
So anyone else?
Hello.
So yeah, go ahead. Go ahead.
Thank you. It's actually good presentation. So myself, Devarchar, I am from 2019 batch pass out from Life
Hello.
Science University. So I have one question that you told that your work should not be published before it got patented, right?
Yeah.
So now actually what happened, we developed a method for actually a 3D printer, extrusion based 3D printer. So actually we bought it from one company, but the problem is that the company itself for one particular type of material they was not able to optimize the protocol for the means company
Okay.
person, they were even not aware about how to optimize this protocol for the 3D printer. So what we did in course of like for 2 years, some people they worked and we have developed one that particular thing, and the company people they told us that you have developed this thing, so you give us a consultancy on this, like for their service for our PhD scholars. So we are actually thinking of this patent thing, but we don't have much knowledge that how to file the patent. And so now we have agreed with them.
You should
Company,
actually, before
they
giving your
actually
consultancy
they,
services, you should file a patent because
they
then they
actually
will claim the right on it.
no, they actually offered us very good amount of money.
See, that's what I was
So,
giving an example.
so we got tempted and we signed agreement
If
with
you
them
don't
that we
know
will.
anything, just go for a provisional application. Whatever new method you have come up with, obviously you'll refer to their equipment because that is already present in the market. The method which you have come up with, you just write down it in a paper and just file a non-provisional application. And then you'll have 1 year. You'll have 1 year. Obviously, they'll come after you and you let them know that you have filed a non-provisional application. They'll come after you and obviously they'll say that no, that is their equipment and you have come up something. But then you'll have the ball in your court that what you want to do. You should file a non-provisional application first and you'll have a year and then you can come up with something, a concrete thing for filing a non-provisional application.
So, what will be this approximate cost for filing for
If
non-provisional?
if an individual person is filing, if your institute is not filing, if you are filing, then it's around 7,000 or 8,000. And if an institute is filing, I guess it's 20,000. I'm not sure. You can check that IPO site.
And
It has.
for getting like till the final, it's like you told it will be take approximately 4.5 to 5 years for getting. So,
Yeah, you will get,
so
but once it is published, and it'll published, once it is published, and everyone is known that that is your work. Publishing generally happens after 18 months of filing. If you're filing tomorrow, then from tomorrow onwards, 18 months, the application will be published and will be on every public domain. So people will know that that is your thing. No one can then copy you. After publication, you'll have the lawsuit rights.
no, actually that work also partially we published already. So,
So it's already in the market.
no, not full process, but part of the
But if
product.
it is published, and 1 year grace period is gone, then you cannot file a patent because what examiner do is they generally do the searching. When the rejections or objections come, there's a proper list of patent or the non-literature. What we call non-literature patents is like these publications or journals. If that subject matter is disclosed anywhere, even in the newspaper, then you cannot file a patent.
Okay, thank you.
So, but see, this is a nice example. If you have something and if you come up with something, we science student, we come up one or the other thing any day, but we don't pay heed to that, and that chance goes from our hand. So we have to be vigilant about it right now. That's the thing I wanted to tell you all.
Okay, that's good. So let's have our Rashtragan and we will conclude this.
Okay, so.
So someone sing